Morning, ladies and gentlemen. Welcome to Magic Bricks Hangout series. Our endeavor is to trigger a buy and bring back consumer confidence in the real estate market. The topic of today's session is tackling legal real estate hurdles after a disaster. To discuss on the same, we have S. Vijayaraghavan. He's a senior advocate in Madras High Court, trained under former advocate General V.K. 3 Venkateshwari and V. Srinivasan, member Madras Bar Association. He has 37 years of experience and is member Bar Council of India, Madras High Court Advocates Association and British Business Group. Other than appearing in Madras High Court and other courts of Chennai, he has also appeared in Calcutta, Bombay, Bangalore High Court and occasionally at Supreme High Court. He has also been appointed as advisor to several corporate groups and private individual clients. So without any further delay, we'll take up the queries now. Over to you, Neha.
Hi, Mr. Vijayaraghavan. We have flooded with a lot of queries. Now let's start with queries. The first query is from Namrata. She asked, when faced with a disastrous situation, you may find yourself in a need of legal advice. How can we address the issue of disaster management in India?
Yeah, disaster management in India is still in its fledgling state. We in India, unfortunately, respond to disasters after they have happened. We don't really prepare for ourselves for that. One of the best things that I can tell all the viewers here would be to first, with regard to matters such as this, take a proper insurance policy with regard to all your important assets and things that you value in life. Remember, in all these insurance policies, there is a dangerous clause called the vis major clause. The vis major clause exempts the insurance company from liability in the event of earthquakes, floods, and other natural disasters like lightning, etc. But there are insurance policies where you specifically provide for the companies compensating you for losses arising out of floods, for example, or earthquakes or whatever. So it would be wise for most people to get into an insurance policy, but read the terms of the insurance policy very carefully. There are a lot of fine prints which will exclude liability for the insurance company. Ensure that you enlist all the assets that are in your house, in your place of business, and cover them and pay a proper premium. Nothing may happen to it year after year. You may think it's a waste, but it's precisely for that you take a policy. You don't want to encash on the policy. You just don't want these things to happen. If they happen, then it's important that you get a proper compensation. This will be the best thing for you. Apart from various other aspects from the legal angle, this is what I would suggest.
Okay. I would like to ask a query on behalf of the consumers. As we know that every day we face such kind of a query. A consumer asks that what one should check before booking an apartment in terms of when we see that these natural disasters are challenging the construction quality of real estate in India. So they keep on asking that what is the thing they should check apart from the background of a developer, legality issues in terms of documentation and everything. What else one should check pertaining to legal aspects, so that if the situation like this occurs, a consumer is not the only one who faces the brunt.
Yes, most of these problems, unfortunately, today, like this flooding or even earthquakes, have arisen because of improper development. In every city, there are proper rules and regulations to guide development. And there are also rules and regulations regarding where to construct, how much to construct, how tall can a building be, what is the extent to which is constructed. So the first and foremost thing you'll have to see is whether proper sanctions have been obtained by the builder. Don't go in for necessarily the cheapest construction, because the cheaper the construction is, obviously he will cut on the corners. The question of using inferior cement, mud, and all these things are matters that you may have to check up with some civil engineer. But always remember, the best thing is to have a decent builder with a good reputation, because you can take it for granted a good builder who thrives on his reputation will not ruin it in your project and thereby loses bulk of his business. This is apart from the fact, I want you to know there's a general tendency even amongst consumers to think that constructions made without proper sanctions will be somehow later regularized. Today, the Supreme Court has come down heavily on improper construction or construction without sanctions, to the
Right.
extent of having asking people to demolish what has been constructed without sanction. Also, excessive construction in a small plot and without sufficient foundation, and also in seismically unstable areas, there are methods of construction where even if there's an earthquake, for example, the building sways and doesn't bend or break. There are methods for this. You may want to check up with the engineer involved with the construction whether he has provided for seismic safety or for possible earthquakes in that area. Also, see, when you choose a low-lying area, you can't blame the builder for flooding. You know it's a low-lying area, the cost will be cheaper. So you are inviting it on yourself by buying an apartment in an area which has been recently reclaimed from a lake or a low-lying area. Naturally, the water flows down. So these are some of the say, and also please remember in all these matters, take the advice of a competent lawyer who is not out to cheat you or charge you heavily. In every city, there are very honest, genuine, intelligent lawyers who are out to give these opinions. Take their opinion. Don't throw good money on bad. The small fee that you pay the lawyer to a competent lawyer will be useful. It can prevent you from greater losses in future. Don't think my neighbor has bought it, five others have bought it. Can it go wrong? There is
Right.
this is the mentality that always rules many buyers. They just want to save a small amount of money for professional advice and then lose out on big amounts. This is the best general advice I can give on this,
Right.
apart from the insurance policy that I already spoke to you. Yes.
Right. Quite an insightful information from your end, sir. Another person, his name is Bose Muthu Kumaran, who works with a financial services company in Chennai.
Hmm.
He bought an apartment in CTO colony
Hmm.
in Tambaram
Hmm.
2 years ago. During the recent rains, water entered his apartment and damaged the building and its belongings.
Hmm.
So he has got this concern, and he says that what should he do? He also asked that the apartment was bought on a loan. My EMI is running. I know I will end up paying almost rupees 50 to 60 lakh for my loan of rupees 35 lakh for this apartment. Now thinking back, it seems like madness. I could have paid rent and stayed at a better place.
Hmm.
So such kind of queries, people have, and they say that is there any way that this can be tackled legally?
Yes. No, I will. Yes. Can I answer you?
Sure.
Yes.
Sure.
What you will have to remember in these matters is that if the water had entered his premises because of a faulty design or a faulty construction, or
Right.
even contrary to the plan approved by the corporation, then
Right.
certainly he can question the builder himself, ask to tell him that he is responsible for the special laws, not just the floods.
Right.
And apart from claiming from the insurance company for the floods, he can say the builder is the cause of this accident, for
Right.
at least aggravating the accident because of his faulty design, because of his faulty construction or illegal construction. In such a case, he doesn't have to go to the civil court and pay extensively on court fee. He
Right.
can he can tap at the doors of the consumer forums, which are there all over the country, take the builder to task, claim a compensation from him if he is able to prove this. Otherwise, if the flooding has happened only because of a low-lying area, then that will be a matter to be covered by the insurance policies. The third and last thing is if he feels that the government or the corporation has, by its inaction, aggravated this flood situation by not maintaining the roads properly or letting out the water at the wrong time, leading to a sudden aggravation of the floods, which has
Right.
caused this, then he can sue the government itself or the corporation or the CMDA. Wherever he finds there is a fault, they can be called in question in a court of law, provided he is able to establish on this individual situation. I don't know where his property is situated. If the matter has been aggravated by the action of the builder, then the builder. If it is by any statutory authority, including the government, he can haul up the government itself and seek compensation.
So he says that his property is situated in Tambaram.
See, Tambaram is considered to be a low-lying area. Okay. Now, if knowing that it's a low-lying area, if he is bought with open eyes, that alone cannot be a ground for compensation. But even in a low-lying area, if the construction is contrary to the building sanction plan, or there have been certain special features by building a basement which is unauthorized and that constituted the flooding,
right,
or some other reason where the builder has been responsible for aggravation, then he can move against the builder himself.
Yeah, he's part
of it's all a question of reading the individual contract. It has to be by a case by case basis. I can only give it the broad general manner in which an investigation can be started. What I'm going to tell your viewers, Neha, will be useful for them when they have a discussion with their lawyer on that individual document, individual case by case basis. They can ask the right questions so that the lawyer can guide them properly and tell them it's worthwhile pursuing the matter or not worthwhile pursuing the matter. You get me?
Right, right. Yes. His part of query says that if this has happened to construction quality, the high-rise get damaged, then can buyer seek a compensation from the developer?
Definitely, definitely. In a case, your question itself gives you the answer. If the quality of the material used is deficient, if the quality is not as, also I would advise all buyers of apartments or non-residential buildings to note one thing. Always insist upon a schedule to your agreement, builder's agreement, where the quality of the material that are to be used are specified. Whether if it's wood, is it going to be teak wood? Certainly rosewood is not going to be, if it's not teak wood, what is the quality or thickness of the wood? The commercial wood that is available. What is going to be the thickness of the walls? What is going to be the quality of the cement? What is the, of course, the need for curing when you construct? All these things should be insisted upon and specified. Read the fine print. Don't sign what the builder has given just because you like the area or you like the style of building. Look at these things. Consult a lawyer who will, and also an engineer who will tell you whether this construction is proper with the kind of thickness of walls, the depth of the foundation.
Right.
Yeah.
Let's take up the next query, sir. Are there any flat cancellation charges? If yes, what percentage are we supposed to pay? This user is from Delhi. Her name is Delhi. She asks that is there any flat cancellation charges?
Yes. See, there is no law which speaks of flat cancellation charges. It's a matter of contract. Each contract with a builder will specify what are the consequences of cancellation after booking. There will usually be some amount that will be deducted from the amount that has been paid by the flat allottee, because it will become the duty of the builder to find a new buyer and give it to him, and so that the construction can go on without being impeded. So, but it can never be the full amount that one has paid. Suppose 10% has been paid as an advance and the person wants to cancel. It can be about 2 or 3 or at the most 5%. I mean, 10 or 25% of the 10% that has been paid. Never an exorbitant amount. So these are things that you should watch out for also when you sign. So I want to make it clear to your viewer, it is not a general rule as to what percentage. It is on a contract to contract basis.
Right. Let's quickly take up a couple of more queries, sir, as we are just, getting close to the ending time.
Yes.
I bought a house with a home insurance scheme offered by a developer. My house was badly affected by the floods. Now, when I am asking for the insurance claim, the developer says he would only give 25% of the total claim. This person is Mr. Philippe from Chennai. So he wants to know what to do about this.
There cannot be an arbitrary position taken by the insurance company that they will pay only 25% of the loss. The question is, what is the coverage?
Okay.
What has been covered? That
Okay.
will be seen by reading of the individual policy. Because as you cover more and more, I want Mr. Philip to know, the insurance premium will increase because the risk factor goes up for the insurance company.
Okay.
Many clients of mine, in order to reduce the premium, reduce also the coverage. Items covered or the value stated. If you yourself have undervalued your property and given a coverage for a lower amount, then you end up getting less in case of an accident like this. So what I would suggest to Mr. Philip is, I don't want to answer him at random, but the insurance companies cannot straight away say I will give only 25%. They have to give the reasons for it as to why they are only clearing 25%. There will be something called a survey. In that survey, the damages would be assessed.
Right.
Get the surveyor's report, see what is the extent of damage that the surveyor has done. The surveyor has made a mistake, question it. If at the end of it you're still not satisfied that they have abided by the contract, even the insurance company can be taken to the consumer court, saying, having promised to take care of my damages, you're only giving 25% on an unreasonable ground, not warranted by the contract. That should be your stand.
Right. Right. Another query is from Anand in Delhi. He asked if my parents got divorced and decided that they would leave the paid off house they own together to us, their children, who is responsible for transferring the title.
Hmm. I beg your pardon, who is responsible for transferring the title?
He asked that if my parents got divorced and decided that they would leave the paid off house they owned
Yes.
together to
No,
us, together
please.
to us, their children, who is responsible for transferring the title.
If the property belongs to the parents jointly, the parents will have to transfer it by a deed of sale in favor of the children. Now, if it is to be given to them after their lifetimes, a will can be executed. Now, if it's not a sale, but rather a settlement, a mere settlement deed or a gift can be given by the parents to the children straight away, and it has to be registered because no property of 100 and above can be transferred without registration and execution of a document. I don't think the children are buying from the parents as such, so it will be a settlement or a gift, or it can be by will if it is to take place after their lifetime. But even during their lifetimes, if the parents want a life interest, they can have a settlement deed saying, we will have life interest, after us it will go to our children. Absolutely. Is the way
Right.
to do it.
Okay. There's a Bireshwar Banerjee who asks if a warranty deed lists 3 owners, but 2 are deceased. Does the sole survivor need to pay any type of inheritance tax?
Can I have the question repeated, Neha,
Sure.
quickly?
If a warranty deed lists 3 owners, but 2 are deceased, does the sole survivor need to pay any type of inheritance tax?
No, there is no inheritance tax as such if the third person is a legal heir of those two persons who died, and he or she automatically gets it under the laws of succession. Otherwise, if it's some third party who has died, the two of them who have died are not related, then their shares will go to their respective legal heirs from whom this survivor will have to get his title.
Right.
I hope I've made my point clear.
Yeah, okay. Um, this John from Goa, sir, he asked if natural disaster like earthquake or flood causes damages to a newly constructed project, then can I recover the cost of damages from the developer?
Yes, this again is a question. Just because it is newly constructed, if
Right,
something severe happens that is beyond the control of the builder, he will not be responsible. But if the damage has happened because of the faulty or poor construction, then definitely the builder can be hauled up in a consumer court, even in Goa, for which I think he should take the advice of a proper civil engineer who will tell him that the water has entered or the damage has been done because of poor use of cement or steel quality or the thickness of the walls, which is contrary to the established industry practice.
right, right.
Using that, you should go to a lawyer and move the consumer court. And it's not expensive doing it before the consumer court.
Right. There's a person from Bangalore, her name is Mehak. She asked, how can I check whether a particular house is insured? What documents do I need to check if the developer, if offered the home insurance?
He has to show the document of insurance. That's all that's required. If the builder has taken a policy of insurance,
Right.
that should be shown and it should be examined by our US lawyer to see whether she's safely covered for any possible third-party accidents.
Right, right. So there's a query from Joby Verghese from Chennai.
Yes.
Uh, he's asking, I'm looking to book a flat. The builder is asking for 1% VAT and 2.575% of service tax.
Yes.
I wanted to know if these demands are legal and if this can be vary from the builder to builder and whether it can be negotiated.
See, the statutory dues have to be paid, and they have to be paid by the builder. It is customary for the builder to collect from the consumer, namely the flat buyer. So there is no question of negotiation in these matters because the rates are fixed and they have to be necessarily paid.
Right.
They add to the cost of the purchase, but these are not negotiable at all.
Right. Let's take up the last two queries, sir. Uh, there is a person, Mihir from UP. He asked, sir, I had invested a sum of rupees 40 lakh in an apartment since the developer asked for 50% amount. Now the developer is delaying the project, so I asked him to cancel my booking. He's returning only 20 lakh. What legal steps should I follow?
He should immediately approach the consumer court without delay because limitation will cost him dear. From the date he refused to give the 30 lakhs but gave only the 20 lakhs, his limitation time will start. Let him go to the consumer court and say it is deficient service and he has to necessarily return it. He has neither kept his word. He can even ask for an additional compensation beyond the 30 lakhs that is due to him for delay because the costs of a new flat would have gone up by now. And because of this man's delay, the consumer is forced to pay more to a new buyer, new builder, isn't it? So that amount can also be made a part of the compensation. It's a clear case of deficiency in service, which comes under the Consumer Protection Act 1986.
Right. Let's take up the last query, sir. It's Shrikant, who has bought an apartment in Perambakam just a few months ago, and his house and furniture have been spoiled by the water that flooded his apartment on December 2. He says that I bought that apartment only in June. They said it's a lake view apartment. They said it's a lake view apartment, but the entire place looks like a lake now. I don't want to go back to that apartment, but I've had my bad memories of it now. But if I sell it now, I don't know if I'll get my capital back. So in this case, is there any way to help him out in terms of getting the money from the builder?
Yes, yes. You know, Perumbakam is a low-lying area that suddenly shot up in value because many builders found that an attractive destination. Since I'm in Chennai, I know about it, I can tell him about it. Unfortunately, what happened was, being a low-lying area, it was more prone to the flooding. As I told you to your earlier viewers, there are only two things that I can speak with regard to the flooding. If the flooding has happened because of the statutory authorities letting the water wrongly or excessively without sufficient warning, then he can sue the statutory authorities, whether it's the government or the local panchayat or whatever that did it. As regards the damage caused, he again has to take the help of a civil engineer to see whether the damage caused by the water is much more than it normally should be because of poor construction materials.
Right.
The materials are deficient, and because of that, what should have been about 10 lakhs has become 30 lakhs. Then the balance 20 lakhs will have to be borne by the builder, who promised a good and proper construction under the builder's agreement. So this is the way to go about it. In the meantime, always when property values have come down, it is important not to be in a rush and to sell them away. While the memory of the floods is there, nobody will go near Perumbakam now, knowing that he ought to wait for the right time. Real estate has certain characteristics whereby suddenly the prices shoot up and he should wait for that. And Perumbakam had a sudden shoot up,
Right.
of which he was the beneficiary. But
Right.
now the converse has happened, which is rather unusual because real estate never usually comes down. But
Right.
because of this floods and the memory, unless he wants a distress sale, I would suggest that he should bide his time and wait for market to improve before he sells.
Right.
In the
I
meantime,
think
if you proceed again. Yeah, please tell me.
I think we are running out of time, sir. I would like you to give your closing remarks to the consumer that how
Yes,
just give in 5 quick points that how they can check
yes,
before investing their huge sum of money. So
yes.
we'll
For most people, it's their life savings that they're investing. It's not just throwing 100 rupees in a mall for a small plastic tank. So please take these following important. I could go on with 100 precautions. I'll give you the most basic. First and foremost, check the title of the property carefully, scrutinize it. Second, see whether all sanctions from the authorities like the corporation CMDA have been obtained. Three, ensure that the construction is completed in stages and whether each stage is completed in time. And provide for a clause where if it is not done, you have a right to exit without loss of any amount. Because the construction is not completed dramatically in 2 years.
right.
It has several stages, foundation, then lintel level. So each of them has to be done within 2 months, 3 months. See whether these milestones are observed. Please have your construction and other agreements checked by a competent lawyer.
Right.
Fifth, and finally, please visit the site every now and then to see that nothing untoward is happening and even take the help of a competent civil engineer. The sixth point that I would like to add to all of you is ensure that you don't indulge in any black money transactions. Go for a straightforward builder who does everything for you above all. Seventh is please look for a reputation because even at the best of contracts, you may have litigation if the man is a crook. Not everybody is a crook, a small percentage is a, you should not get caught in it. So generally, a builder with a reputation for delivering several projects, you can be assured that he will not ruin his reputation on
Right.
one project just to make an extra few bucks. These would be the general safeguards. Also see about insurance policies, about safeguards taken in that measure, and also see the depth of the foundation and see the location of the plot itself. Just because it is coming cheap, don't go by a herd instinct. Very often herd instinct rules because people come to me in large numbers and say, 10 or 15 of us have been affected. Why did you do it? He was buying it, therefore I bought it. If he had bought it, it must be right. Each of you please check up your titles separately. Don't go by other people. So they
Right.
may all have been misled, and you don't want to be misled by other people's mistakes. I think I've answered.
Thank you. Thank you so much, sir, for your valuable time. There are a lot of queries coming in, but we'll take those offline with you.
Yeah.
I would like to thank you once again for giving us an opportunity to have you on the board. Over to you, Pushpa.
I'm really thankful to our guest speaker, Mr. S. Vijayaraghavan, for participating in this Hangout session. It was indeed a great session. I would also like to thank all our participants for their support in making this Hangout a great success. Thank you, Mr. Vijayaraghavan. Thank you, Neha.
Thank you, Pushpa.